begin taking a look at some of these court opinions that have been coming down on this unprecedented presidency and how the courts are responding to it. This is one of my loves, actually, as a journalist, and I'm glad to see you here. Hi, how are you? Star, Jed, Cali Girl 61. This one's for you because this is all about the case that came down today. A district court judge's ruling. Judge Charles Breyer, who is actually the younger brother of Supreme Court Justice Stephen Breyer, former Supreme Court Justice Stephen Breyer. And the question in this case is Trump's deployment of the National Guard in Los Angeles, right? And the reason, obviously, this is so important is because this is the plan. This is the plan for all of us, right? So I kind of wanted to step through the opinion, which I liked, partly because I'm a geek for this kind of stuff. I did it for a long time with ABC News, but also because I think this case is one of the many that are in the court system right now where lower court judges are trying to sound the alarm. Okay, district court judges out there who keep getting knocked down, certainly by the Supreme Court and by appellate courts increasingly, are saying we are on the ground. We are the fact finders, right? That one of the things that trial courts do, that district courts do in the United States system, is they develop the facts. What happened here? And that's what this opinion is about a lot. And therefore, how should we look at it in law? One of the things that's been shocking to me, and I think to a lot of people who cover the law, and certainly a lot of people who know it better than I do. I'm an amateur, which is one of the reasons I think I was good at doing this kind of stuff, because I had to, I'm not a lawyer, right? So I had to translate legalese into my own language and put it inside of me in a way that I could communicate it clearly. Let's hope I can do that here. So in the context of it, though, is that the trial court judges keep getting knocked down, and they're the ones who develop the facts. And so it's been shocking to, much smarter people than I am, a lot of law professors, to see the Supreme Court. Trump is on a 16-case winning streak at the Supreme Court of the United States. And they have allowed the bulk of what we now understand as Trumpism, a concentration of heretofore unthought of powers in the hands of one man, in the hands of the President of the United States. And the Supreme Court has green-lighted, at this point, much of the Trump agenda, right? The giant cuts and rescissions in congressionally authorized spending. The president essentially doing the budget in ways that would have shocked the people who wrote the Constitution, all the way to the deployment of federal forces in American cities on the flimsiest of pretext that there's a rebellion or an invasion or that kind of thing. So that's what's been so shocking, is to see the court greenlight all of this without even looking at the facts, before there was even a trial in some of these cases, to show the court what is actually happening on the ground. They're essentially firing off these decisions, these rulings, these orders, I should say. They aren't rulings of the court, they're orders of the court. Go ahead. You can't stop the president from doing that at this point. They suggested maybe they'll take a look at some of these issues later, but really, they're, for all practical purposes, greenlighting the Trump agenda. And they're doing so without the benefit of the lower courts. Okay, so the whole idea is the lower courts, they hear witnesses. They develop the facts. They determine, based on their individual understanding of what the law requires and the facts that they've seen in their own courtroom, here's what the decision should be. That gets sent up to the appeals court, who look at it through all the lens of the precedents and the laws, and they take a fresh look at. And then it gets to the Supreme Court. So there's this percolation that's supposed to happen up to the Supreme Court so that the justices of the Supreme Court can take a look at it. That's not happening. And I think what I want to go through a little bit in Judge Breyer's opinion is he's almost like calling out the Supreme Court in this opinion. He is, and frankly, there was an earlier case on the presence of the troops in Los Angeles that got overturned by the Ninth Circuit, by the circuit court that is in charge of California. And he's pleading with them, take a look at what's really happening. Okay, so this is, you may remember, that case that already happened, and that was a case where Governor Newsom of California sued the president. Newsom versus Trump is the name of that case, in order to stop the deployment of military forces on the streets of Los Angeles. And the grounds of that was partly the 10th Amendment of the Constitution, which reserves all the powers, all the rights not specifically mentioned in the Bill of Rights, to the people and the states. So it's the States' Rights Amendment. And they said, Newsom's lawyers said, this is clearly an invasion of our state by the federal government. We don't, that can't be countenanced under the 10th Amendment. And without saying why, Supreme Court of the United States basically kind of punted on that. So this is also Newsom versus Trump. But this case, in which Governor Newsom is suing Donald Trump for sending federal troops into the streets of Los Angeles, and once again, those federal troops are expected already in Washington. I just did a story on the impact on Washington. You can find it on this Substack, but also coming to Chicago this week, it seems, and elsewhere. Trump has threatened Baltimore, Oakland, all kinds of cities. As you know, not the highest crime rates in the country. Those are in a lot of red states. He's going after those cities governed by Democrats, essentially, who are in charge of those cities. This case is brought by Governor Newsom and his lawyers under the Posse Comitatus Act. That's that act in 1878, after the presidential election of 1876. I want to just read it because this is the context. So this is a law that hasn't been tested much over the years, but this is the Posse Comitatus Act in its entirety. And it goes like this. Whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army or the Air Force as a posse comitatus or otherwise to execute the laws, shall be fined under this title or imprisoned not more than 2 years or both. All right, so it's actually a criminal statute. It's the Governor Newsom is not looking for any criminal sanctions here, but he's looking to stop this use of federal force. So if you, like me, see Trump's overeager deployment of military force against our cities on the flimsiest of pretexts as part of what is clear by now to anyone with eyes, an authoritarian project for Trump to concentrate power in his hands. If you see these troops that way, this case was meant for you. And that is what Posse Comitatus law was meant to stop, precisely what it was meant to stop. Now, one more prefatory note before I start digging in here, and that's what's going on with the Supreme Court, right? I wrote something about this. I'm not, you can slice and dice the law in a lot of different ways, although they aren't doing that, as I say. But one of the things that I think is important to remember, and that is who's on this court, right? And I'm not talking about Republicans or Democrats. I'm talking about something very different. I'm talking about what do they bring to the Supreme Court of the United States? And having spent time, a lot of time over almost 30 years going up to the court and seeing them in action personally during oral argument and reading their opinions over the years and kind of getting a sense of who they are. And occasionally, very occasionally, meeting and chatting with them one-on-one, it does seem that we have a court that is not up to it. They aren't up to this moment. And why not? Well, I did write something about it. I'm going to quote myself here. I wrote a Substack on the court. I said I called it Our Clueless Supreme Court. And it's not really that they're vicious politically, although, you do look sometimes at, I think, Samuel Alito, more so even than Clarence Thomas. Thomas has always had this vision of the world. Now he's been paid handsomely over the years by the Republican Party, so maybe that has something to do with it. But Alito seems a genuine political, cultural warrior to me, and very, very deferential to Trump. But actually, I think even beyond that, there's something more. So why are they failing us in these ways, the Supreme Court justices? I don't think they're up to the moment because they're too small. And by that, I mean, for much of our history, Supreme Court justices were chosen not just from the narrowest strain of federal appellate lawyers and judges. They were chosen from our polity, our political life, as well as our legal life. And maybe you didn't see this. So if you take the greatest thing the Supreme Court ever did was Brown versus Board of Education, right? So it struck down separate but equal as constitutional in the United States. It's separate but equal is inherently unconstitutional and began the ending of apartheid in America. It's the greatest thing the court has ever done. No question. Who was on that court? A former governor of California, a former U.S. senator from Alabama, a former member of the Kentucky House of Representatives, a former law professor, top White House advisor, and founder of the ACLU, a former chairman of the Securities and Exchange Commission, a former attorney general of the United States, a former senator from Ohio, another former attorney general of the United States, and a former senator from Indiana. So you had a governor, 3 senators, 2 U.S. attorney generals, the head of the SEC, and one of the most prominent public intellectuals of his time and a close advisor to Franklin Roosevelt. These were men, all men of state. They had practical experience with power in their hands. They knew how it worked. They knew how it felt. They knew what the temptations were. They knew what the limits were. The last Supreme Court justice to sit on the Supreme Court of the United States, having had political office, was Sandra Day O'Connor. She started out her career running for the state Senate in Arizona. She was elected to the state Senate and in Arizona, and ran for office again when she ran for the state Supreme Court. That's an elected court in Arizona, as it is in many states. And so she had a 15-year career in elective politics and in the hurly-burly of the legislature. Interesting fun fact, she had been there like 2 years in the state Senate of Arizona. When all of those guys, most of them were guys at that point, they looked at her, they said, she should be the Senate Majority Leader. And she was. So she had real authoritative experience holding power. Citizens United was decided the year after Sandra Day O'Connor left the court to care for her husband, who had Alzheimer's. You may remember. And she indicated publicly, that she would have voted the other way. Citizens United, in which the court said, well, you can't have campaign finance restrictions on money spent by corporations because corporations have free speech and money is speech. And when it comes to politics, it's a way of expressing yourself. And Sandra O'Connor said something like, I ran for office. She didn't say it quite like this, but she made clear this is what I know money isn't speech in politics. Money is money. And that's just one example of the concrete experience, the way the law can be shaped by somebody who knows what the heck they're talking about. Who do we have now? Now, I have nothing against these people, seriously. But they're all basically the same, right? They're all federal appellate lawyers. They've all worked, almost all of them have worked in the executive branch, where their job as an executive branch lawyer is to defend what the president's interests are, to defend what the president does. I mean, to a man with a hammer, everything looks like a nail. And if you're a federal appellate lawyer, if your history was in the executive branch, it looks like, everything is about the presidency. But more than that even, is their life experiences are so limited. Now, you have real life experiences, and they all bring that to the table in interesting ways. Obviously, Justice Sonia Sotomayor brings her experience. Clarence Thomas brings his experience, whether you like it or not. It's real, him. That chip on the shoulder he's got about affirmative action and all that shaped his life. But for the most part, their experience is kind of, I was going to say dweeby. I mean, they're very insular. It's like they've been in a convent their whole life. You know what I mean? They're Ivy League. They're what somebody called front row kids, right? They have all the answers. They go to the best schools. They come out thinking in that same way, right? I always thought there should be a landlord-tenant lawyer on the court. Public defender now on the court. Now we do have prosecutors who are on the court, but So I think that explains, in part, why we are seeing such a cowardly, in my judgment, Supreme Court. Why they're unable to meet this moment, they aren't equipped with a firsthand understanding of the exercise of political power and what it can do. I think also, obviously, some of them like the idea of this unitary executive. Has there ever been a more cockamamie idea than this unitary executive? You know, I mean, everything about the founding of the Constitution shows that they were terrified of a powerful executive. They were terrified of it, right? They'd just gotten finished with a war against a king who was doing a lot of crazy stuff. They did not want to supercharge the executive. They developed with great genius, although not perfection, a constitution which had co-equal and coordinate. It's not just co-equal like they're silos, right? They're coordinated. Congress has some power over war making. President has other power over war making. Congress has some power over spending and regulation. President executes those laws and therefore has some interpretive power over that. So, and the courts, certainly since Marbury versus Madison, which we'll hear about here, they have had this opportunity to balance their own interests and the interests of the law. That's the way it's supposed to work. Somehow, all these executive branch lawyers in the federal system, which they get no clue about the state system, except what they read in books and in opinions. They've got no practical experience in it. They've decided that the president was desperately underpowered and threatened in the American system. And obviously in Trump versus the U.S. last year, plucked completely out, not out of thin air, but it's an interpretation of the structure of the Constitution, Trump versus U.S., the immunity ruling. And what happened there was they decided, well, the way we should rule on this case is to silo off the presidency. Any purely executive act, or even an act that can be remotely related to the president's executive authority, is unreviewable, unprosecutable, not unreviewable, but unprosecutable. And they're very deferential when it comes to reviewing the legality of the president's actions. Justice Sonia Sotomayor's dissent in that case is one of the great dissents. You got to read it. She's like, you guys are all about the history and tradition. I'll give you some history and tradition on executive power. They raised the question in the Constitutional Convention, should we give the president immunity? They called it privileges. That was in the Constitutional Convention. And here are these history and tradition guys who got to do whatever the founders tell us. What did they do? They didn't put one in. They didn't put any immunity in. Plenty of presidents thought they did not have immunity from criminal prosecution for what they did in office. Clearly, Richard Nixon, who accepted a pardon, thought he could be prosecuted. He was one of the presidents. Gerald Ford issued that pardon. He was one of the presidents. Bill Clinton cut a deal to avoid, he lost his law license to avoid prosecution. He certainly thought he could be prosecuted. But the Supreme Court cooked up this idea presidents can't be prosecuted. And so now we have this, and that's now been taken and run with. The principle underlying Trump versus U.S. is how Trump's lawyers are arguing he can do anything. He can send troops to your streets, right? He can slash the federal government. These departments and agencies established by acts of Congress, he can slice them to pieces because, we don't really have the power to review it. As long as he makes a colorable argument that it's part of his core executive authority, we can't second guess it. And that's what's at stake here. And that's why Judge Breyer's opinion is so important. So we go back then to the Posse Comitatus Act, right, of 1878, and its basic text that you can't use the army as a posse comitatus or otherwise to execute the laws. You can't use the military to execute the law. So how does Judge Breyer begin this opinion? He says, Congress spoke clearly in 1878 when it passed the Posse Comitatus Act, prohibiting the use of the U.S. military to execute domestic law. He then says, well, then Trump send these soldiers, National Guard troops and Marines into Los Angeles on the basis that there would ostensibly to quell a rebellion. And Breyer says there was no rebellion, nor was civilian law enforcement unable to respond to protests and enforce the law. Nevertheless, at defendant's orders and contrary to Congress's explicit instruction, federal troops executed the law. Congress's explicit instruction is the Posse Comitatus Act. Remember, it's the laws that govern us, not executive orders, not one man. It's the laws passed by our representatives in Congress. There's a reason it's Article 1, right? There's a reason because it's the closest to the people. It's the reason they put the power of the purse with Congress, because it's closest to the people who would be paying the taxes or whatever. The power of tariffs, because they're the people who own the businesses or are bringing in the goods from overseas or whatever. The tariff power should be in the hands of Congress. We've gotten used to this supercharged presidency. Now we're paying the price. A lot of that was to empower liberal ideals. And now we're paying the price because this is a guy, and not just him, he instinctually wants to grab power, it seems to me, the president. But he's got really smart people around him this time, and they're looking for every creak and crevice and crack in the law, and they are just wrenching that open to pour authority into the presidency of the United States. And they're finding a lot of these National Emergencies Act. Well, Congress doesn't want to be bothered actually with writing environmental laws or whatever, because they're too complicated. And so in case of emergency, the president can impose tariffs, the president can do this, can do that. And now, of course, Trump is just running away with that. So that's the basic idea. Did he violate the Posse Comitatus Act and sending putting National Guard troops on the streets of Los Angeles? The judge says yes. Violated because why? Why did they violate it? This is not an academic exercise for this judge. He's a trial court judge, because he says the evidence at trial established that defendants systematically used armed soldiers, whose identity was often obscured by protective armor, and military vehicles to set up protective perimeters and traffic blockades, to engage in crowd control, and otherwise demonstrate a military presence in and around Los Angeles. In short, the defendants violated the Posse Comitatus Act. So that's what this ruling is based on. It's not an argument. I think this, you think that. He says, listen to the findings of fact, right? I don't know if that works there, or sometimes it flips it around. So the judge recites the history of the protests when ICE came into LA, started making immigration arrests. People hit the streets. There were some protests, right? And some of them got out of hand, right? Some protesters threw concrete chunks, bottles of liquid, and other objects at Federal Protective Service officers guarding a parking garage gate, while others tried to use large rolling commercial dumpsters as a battering ram to breach the parking garage gate. It was a parking garage for a federal building. Some protesters threw rocks and other objects, including mangoes. No, this is serious. Fireworks and a Molotov cocktail, burned a vehicle, barricaded the street with shopping carts, briefly trapped an ICE agent in a car, and vandalized property. Now that ain't right. I'm sorry. I'm conservative that way. I love protests. I've seen a lot of protests in my life. One of the things I was always told as a journalist, if you're covering a protest, always look up because people are throwing things, and journalists and others have gotten bad head injuries for it. But okay, so there's lawlessness, right? Los Angeles Police Department is a pretty big police force. I think it's the largest in the nation. And there was like one car set on fire, right? How often did Fox News and Newsmax and the Onanistic Network, or whatever that thing is, how often did they show that one car burning over and over and over? All right. Well, they showed it a lot, and they showed it sufficiently so that President Trump could declare that violent protests threaten the security of and significant damage to federal immigration detention facilities and other federal property. That was invoking the law that allows the president to suppress a rebellion, right? Can he suppress a rebellion? One burning car and some jerkwads running a dumpster into a parking garage gate, and, throwing a Molotov cocktail. These are bad things. You don't need to make a federal case out of it. And you certainly don't need to bring the federal army into it. But that's not what this is about, is it? Trump is, somebody said, priming us to live with the military on our streets. That is what I believe. That's what's happening. I saw my dear friend and former colleague Martha Raddatz interviewing Governor Wes Moore of Maryland. I think I'm going to interview him in a few days as well. It was a good girl, and you can think what you want, but there's one thing and I love Martha, and I think she's one of the best journalists I've ever known. Rock solid, reliable, excellent person. But my journalistic disagreement with her is she kept saying, well, the mayor of D.C. is happy that the troops came and crime did come down. And, didn't get into, well, D.C. is a federal district, and so there are different laws. But why do we want the military to be doing that everywhere? Because you're accepting Trump's framing. It was all about crime. It's not all about crime. It's not all about crime. Remember when Gavin Newsom held a press conference to announce this lawsuit, I believe, and all of a sudden there were armed federal agents outside at the moment he hit the podium with their district commander leading them. They arrested one strawberry vendor. That was a show of force by the federal government, armed force, against a peaceful political event. I thought that was an extraordinary moment in our history. Everybody says, oh, Trump's just doing PR. That ain't PR. That is what that is. Let's return to the opinion at hand. So one thing that Judge Breyer notes, he says that Trump's memorandum under this, you have the right to call out the troops in the United States of America in order to quell a rebellion, is that it never mentioned Los Angeles or California. It instructed the Secretary of Defense to coordinate with the governors of the states in identifying and ordering into federal service the appropriate members and units of the National Guard. In other words, they can just add this now, add troops into other places using this if they want. So what I really want to get to, though, is what happened at trial. Okay, what happened when the judge called witnesses, put them under oath, and said, what is going on here? All right, so among the witnesses is Mr. Harrington is one of the first witnesses that was called. He is the Deputy Chief of Staff of the Army North, U.S. Army North. He's the Deputy Chief of Staff, William Harrington, and he took the witness stand, and he said the first thing that they did when they recognized they were getting this order from the president, and they were going to obey it, of course, as they should, is that he wanted to make sure that the troops were properly briefed on what they could and could not do. And so at trial, under oath, William Harrington, Deputy Chief of Staff of U.S. Army North, he told the court that if any National Guard troops were federalized as part of the deployment, they would lose the ability to conduct law enforcement activities because of the Posse Comitatus Act. He told the court that he had told the staff meeting, including the major general in charge, guys, we can't do law enforcement. Everybody understood that. They understood that perfectly. To Mr. Harrington's knowledge, everyone in the U.S. Northern Command knew that the Posse Comitatus Act applied, and no one expressed a contrary view because they're soldiers. One of the things you hear in these witnesses is you hear how great our Army is in a lot of ways, One of the things Trump is doing, and I heard this the other day from a friend in the neighborhood who is a lieutenant colonel, and he said they're weeding out all lieutenant colonels for promotion who don't swear allegiance to Trump, basically, who aren't good. He wants his army, right? And one of the things you get in the recent decades is that it's our army. I've been to 2 or 3 graduations at West Point. The American rainbow at West Point is amazing to watch. And that's who you hear. You hear people whose first loyalty is the Constitution. So the task force that is used to do this is called Task Force 51, and they started receiving training right after Trump gave the order. Major General Scott Sherman, the Deputy Commanding General, testified that his number 2 priority as the commander of this mission, number 1, was the troops' welfare and safety. Take care of the troops, keep them safe. But his number 2 priority, quote, was to ensure that they followed the standing rules on the use of force exactly as was written. That's a major general saying that's what he wanted to make sure that they, accordingly, he ensured that Task Force 51 troops knew that they, quote, they weren't allowed to do any law enforcement actions. Law enforcement had to do it themselves. So they were told, members of the task force, soldiers in the task, that they could not impede vehicle or pedestrian traffic or block public roads because these were law enforcement functions. Now, so here is the training material on that. Oh, I see that as all backwards. If you do, I'm sorry, I'll read it off to you. But just if you can take a glance and I'll read it to you. This is the slide that was presented to all troops who were going onto the streets of Los Angeles and their commanders. These are prohibited law enforcement functions. You can't do this if you're a soldier in America. Pursuit, arrests, apprehension, search, seizure, security patrols, traffic control, crowd control, riot control, evidence collection, interrogation, informant. Additionally, the PCA, the Posse Comitatus Act, prohibits any other activity where civilians are subjected to military authority that is regulatory, prescriptive, or compulsory. You cannot boss around civilians if you're in military uniform. You can't. You can't unless there is a bona fide rebellion. All right, so that is one way that the judge heard what was at stake here, that the Army understood their actions not to be law enforcement activities under the Posse Comitatus Act, that they weren't allowed to do any of that. So, however, Washington, Hegseth, they accepted 4 of those activities that are normally considered, in this slide, here's your prohibited law enforcement functions: security patrols, traffic control, crowd control, riot control. Hegseth said they can do that. They're allowed to do that because they have to protect federal buildings. They have to make sure that federal agents, the ICE agents, and the others who are going out making arrests are safe. And they wanted to make sure that they could set up perimeters and block roads. In defiance, the judge finds of the Posse Comitatus Act. Now, that will be one of the issues on appeal. I don't have a lot of hope for this opinion on appeal, I got to tell you, because I think our judges are kind of chicken at this point. They're kind of backing down in some ways. They don't have what it takes to meet this moment. This judge is saying, I'm hearing the evidence. I see what's in front of me. I'm not going to look away. This is an attempted use of the military to subdue the civilian population. And these excuses that there was some kind of rebellion in the streets of Los Angeles, that the Army is necessary to protect federal property and federal officials doing their law enforcement activity. We've had federal property and federal law enforcement activity in this country since there's been a federal government. We don't send out the troops to make sure that things are okay. But that's Hegseth. So they wanted them to be able to block roads. They wanted them to be able to stop traffic, to basically patrol and all the rest of it. So defendants, the federal government, Hegseth's people, they took the position at trial that there did not even need to be an actual threat to federal property, personnel, or functions. Unexpected threats might develop. So just give us a blank check. We found this narrow little pinhole of potential authority. We're going to blow it up. Get out of our way. I mean, I really don't understand how. I feel great being out in Substack. It's wonderful. I do get to speak more like I spoke in the newsroom, frankly. And I know that my colleagues are cabined. I think Martha did a great interview, but when you have to report on this, you got to kind of both sides. You can't say what the thing is. I do believe that the biggest challenge before the country right now is to see what's in front of us and to name it. And that's what this judge is trying to do. That's what Judge Breyer is trying to do. And he notes that the Hegseth's lawyers, Trump's lawyers, said in court, they proposed that even where there is no threat, even when there's no threat, to the safety or security of federal personnel or property, the mere possibility that federal law enforcement agents might not be able to do their job could justify the deployment of Task Force 51. Now, that's an exception that swallows the democracy. If there's the mere possibility that someone, somewhere, somehow, some way might impede a federal officer, and that would permit the use of military force on our streets, look at the thing that's in front of us. I mean, that's what they're arguing in court. He wasn't buying it, but there are higher courts, and they may, in fact. So that is what the judge heard as far as evidence directly from the officers in the military on what they thought they were permitted and not permitted to do, and then heard the defendant's argument, no, we can do a lot of this. And then the judge goes through, once again, very carefully with witnesses, specific instances where they conducted clear law enforcement activities. They raided 3 cannabis farms. Okay, ICE managed to nab some people there. One guy was killed when he fell off a roof trying to get away. One poor fella who was, in this country trying to make a living at a cannabis farm and tried to get away across the roof and fell down and died. So, and he notes that the trial transcript, it was law enforcement in the lead with our soldiers behind them, said the military person. National Guard soldiers established their blocking positions at approximately 0600 on Long Beach Boulevard. So these are specific law enforcement activities, right? That posse comitatus usually forbids, and under the black letter of the law does, without presence of a rebellion, right? Now, one of the things that's the danger here is that it'll get up to the Supreme Court, and the Supreme Court says, "Ooh, we can't do it. Deciding whether something is a rebellion or not, that's not our job. That's core executive responsibility. We can't even second-guess the president." So you got one burning car on Fox News and Newsmax and Associated Accounts and the Onan Network, whatever that thing is, and therefore we have troops on the streets. I just think it's obviously pretextual. They're just looking for an excuse. So the one of the most shocking things. So MacArthur Park. If you know Los Angeles, you know MacArthur Park, and if you're of a certain age, you know that song. Richard Harris. My wife did not know that song, MacArthur Park. She's not of that age. But MacArthur Park, one of the main gathering spots, one of the main parks in Los Angeles. And on Father's Day, right, when a lot of people would be in that park celebrating, perhaps a lot of Latinos, big Latino population there, Father's Day, ICE wanted to not go make arrests, but march through that park. I'll read it to you. They dubbed it Operation Excalibur. These people are so melodramatic. Operation Excalibur involved federal law enforcement officials, ICE, DHS, FBI, who knows, marching across MacArthur Park while Task Force 51, the U.S. Army, National Guard, remained stationed on the outside of the park in military vehicles, Humvees and tactical vehicles, including at 2 traffic control points to prevent vehicular traffic along a stretch of Wilshire Boulevard. DHS's mission, what was their mission? What was Operation Excalibur's mission? To demonstrate through a show of presence the capacity and freedom of maneuver of federal law enforcement within the Los Angeles area, Joint Operations Area. I'm sorry, grow up. Who do? Police officers get in a lot of bad situations. Federal law enforcement officers get in a lot of bad situations. They go into tough neighborhoods, they go into gang-infested neighborhoods, and they have to enforce the law. And we respect them for it when they do it right. We need them. Somebody once said, "Oh, you're anti-police. You don't like the police." Somebody online. I was like, I'm a property-owning Middle East white guy. I love the police. What are you talking about? It's like the people, but poor people, people involved in these neighborhoods where the crime is rampant. They love to see the police do their job. They don't see them doing it enough or doing it right. So here is the pretense of the federal government under Trump. We need to show our strength so that people will obey the commands of federal law enforcement. And so federal law enforcement will be able to work within Los Angeles. Well, the military freaked out. That's the story that's told. The military's like, no, 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 no. That is a bad idea. We do not want, because they thought there might be trouble, and they didn't want to be in the middle of it. They'll help, but they thought it was a provocative act. But they trained for it because they do what they're told. The only identified risk to inaction was the hypothetical concern it could weaken the public's perception of federal responsiveness and reduce deterrence in other areas if the federal presence seems limited or absent. So ultimately, federal law enforcement faced no resistance at MacArthur Park, and Task Force 51 did not need to provide any force protection. The judge includes that because it just shows what was really going on here. The military knew there was no reason for military force. But Trump likes and tags that when people live, right? They're authoritarian-minded people. They like the bristling presence of Humvees and tactical vehicles around your park. You better think twice. That is not America. All right, so then there were the cannabis farm raids, and there are about 300 National Guard remaining. And so the case is still a live one. There's still an injury. What is that injury? All right, so that's the first question that has to be asked in any trial, in any case that anybody brings. How have you been injured? All right, Gavin Newsom, how have you been injured? How have you specifically? So I'm the governor of a state, and he said, well, we're spending more money. The welfare of our people is at stake. The Trump didn't buy a lot of that. He ended up buying as a direct violation of posse comitatus. But he begins with this, okay? And this is interesting because he knows that the upper courts, the higher courts, are going to chicken out. A lot of them, certainly at the Supreme Court. So what does he do? He says, the first thing he says is he quotes the most important case in American history, Marbury versus Madison, in which the great Chief Justice John Marshall said, it is emphatically the province and duty of the judicial department to say what the law is. And that's, without question, this principle applies to cases like this one, where the executive is accused of overstepping bounds set by the legislature, the posse comitatus law, the legislature. So the judiciary has a responsibility to decide cases properly before it. He's basically sounding the alarm. Stop ducking it. Stop chickening out. This is it. This is the over-strong executive that conservatives supposedly were warning of us for decades. This is it. It's happening. Pay attention. You have a responsibility under the Constitution to say what the law is. Say it. I think he's likely to be, again, met with silence or even approval. And he does go back to a very old case. Well, a very old case when President Johnson ordered federal troops to assist local authorities after the riots, after the killing of Martin Luther King Jr. And there was objection to it. The court said, in this instance, it looks like, we aren't going to second guess how bad Los Angeles is burning, how bad Chicago is burning, how badly Washington, D.C. is burning. We're going to essentially let the president deploy these troops to regain order in American cities. Those riots went on for days, by the way, and it wasn't one car burning. It was half a mile of D.C. that didn't recover for decades, charred and beyond recognition. But in that opinion, the Supreme Court said, when presented with claims of injury resulting from military intrusion into the civilian sector, federal courts are fully empowered to consider claims of those asserting injury. There's nothing in our nation's history or in this court's decided cases that can properly be seen as giving any indication that actual or threatened injury by reason of unlawful activities of the military would go unnoticed or unremedied by the federal courts. We get to say what the law is, especially when the troops are put in the streets by the president. And if somebody's been injured, then we go. So the judge then goes on to talk about the history of the Posse Comitatus Act. It's not pretty. I got to tell you, it may save the republic this time, but it was passed in 1878 because in the election of 1876, which is only 11 years after the Civil War, and President Grant was very insistent that Reconstruction mean Reconstruction, that black people get to vote. And so he stationed federal troops at the ballot box throughout the former Confederacy to make sure that black people got the chance to vote. It was a very close election, right? Contested, went to the House of Representatives, very corruptly decided. And in fact, there was a lot of shenanigans about who got to vote at those places and who didn't. It was a viciously partisan time. And the Congress was really upset, especially the Democrats in Congress, because they felt that the election had been impacted, to say the least, by the presence of federal troops at every ballot box in the South. And so they passed the Posse Comitatus Act to get the troops out. Now, clearly, that was one of those steps that undid the result of the Civil War. It was really an anti-black law in some ways. We don't want federal troops guaranteeing the right of the minority in the Confederacy to be able to vote. That is the origin of the Posse Comitatus Act. Nevertheless, it is good law, and there's a good reason for it. It does follow from, as the judge goes on, a lot of our original founding documents. The Federalist Papers talk about, the president should not have the authority, except in the most extreme circumstances, to put federal troops on the ground. But in this case, right, plaintiffs allege that the defendants have violated the Posse Comitatus Act and injured their state. And he kind of rejects a lot of the injuries, but he ends up saying that they have violated the Posse Comitatus Act. Now, the Defense Department, the Trump administration says, wait a minute. That law that allows the president to deploy troops in the moment of rebellion, that's an absolute exception to the Posse Comitatus Act. You can't second guess what a rebellion is, and we have the power to do it. It's unreviewable. You shouldn't even look at this. He rejects that. And then they say, there are other instances. There's just another instance where courts shouldn't be allowed to take a look at 10 U.S.C. 1246.3, which is it's the president's president is empowered to federalize the National Guard whenever the president is unable with regular forces to execute the laws of the United States, right? And that is often deployed. They're deployed in hurricanes and natural disasters because civil society's fallen down in the face of terrible disasters. And they say that supersedes the Posse Comitatus Act. The judge rejects that. So he rejects all their arguments. And at the end of the day, and he says he also has a section, I'm going on now. I found it fascinating. But he does say that there has to be a judicial response. The judiciary has a right to look at this, and they must. Okay, that's the bottom line. And at the end of the day, he says that until some act of force is committed, or there is an assemblage of armed force to resist the execution of the laws of the United States, the executive, the president, has no legal and constitutional power to order the militia to suppress it. So that's actually President Jackson said that, and he was not shy about using federal power, presidential power, that there really has to be an armed rebellion or some way that the laws of the United States cannot be enforced. All right, the last thing I'm going to talk about, you'll know the ruling, but the last thing I'm going to talk about is the new wrinkle, the new pinhole, right, that the lawyers for the Defense Department and the Trump administration are using. They're saying that wherever federal personnel go, the U.S. military is allowed to accompany them. Once again, on the merest possibility that someone might get in their way, which is the broadest grant of authority to deploy military force on the streets imaginable. At some point, the Supreme Court has got to look at this, look at these claims, look at these arguments of the Trump administration, and say, this isn't ordinary business. This is actually the thing that we were warned about by our founders, and we've got to find a way to meet it. We don't have a tremendous confidence in that. So what's the bottom line? All right. Judge Breyer says the court says the Task Force 51 was engaged, and it was instructed to be engaged by civilian authorities engage in certain law enforcement activities. They set up protective perimeters, they use traffic blockades, crowd control, and the like. There is no exception to the Posse Comitatus Act for such conduct. And neither President Trump's June 7th memorandum, that's when he said, I want him out in Los Angeles, nor Secretary Hags's June 23rd memorandum, changed that. The record is replete with evidence that these troops have been doing law enforcement. All right. So I don't know how much clearer it can get. And then so he says that the court will, in fact, stop the defendants from using the U.S. military this way, but he gave them 10 days to get their. It takes a lot to move troops around, but the bottom line is that at the end of the day, the court orders that the defendants are enjoined from deploying, ordering, instructing, training, or using the National Guard currently deployed in California and any military troops heretofore deployed in California to execute the laws. Stop executing the laws. It's not your job. And any including but not limited to arrests, apprehensions, searches, seizures, patrols, traffic control, the like. And they have 10 days to comply with the order. He's giving them 10 days to appeal and 10 days to get the troops organized and back to their bases appropriately. So I wanted to take all that time because I think it's an important opinion, not because it's going to be upheld, not even really, it might even not be this most significant case in what Trump is doing with the military, but it shows one federal judge, Stephen Breyer's younger brother, as it happens, he's 82. There's good genes in that family. But it shows how one federal judge is seeing what is in front of us, naming it, and doing his duty under the Constitution. And I think that's all we can ask of our public officials at this point. So I hope that was not too long. I hope it was interesting. If you did like it, I love doing this, as you can tell. I'm a geek for this stuff. I've been doing it a long time. I think it's important. I think the law is a place where we really do our best to resolve our disputes under principles that are grounded in our traditions, in morality. And there's something big about that, even in the smallest case. I covered trials for 10 years. I'd walk around courthouses, and during the break, I'd go sit in another trial, right? Landlord, tenant, small crimes, whatever. I don't know. I'm very, very much inspired. I actually think it's the branch of government that works the best for us. Right now, at the top, it's letting us down. Judge Breyer and a lot of other lower court judges who see the facts in front of them and bring them into court, they're doing better. I hope we all do better. Look, if you like it, subscribe. Paid subscriptions are always appreciated. And so being an independent journalist is great. I love it. It's liberating and exhilarating and daunting in its own way. But look, thanks for being with us. I'll be back, maybe with another big opinion. If you like, fire away, and I'll try and follow up because we've got some other big opinions today. But this one really hit me here. Thanks a lot. See ya.